New Jersey's criminal justice system changes January 1st, 2017. Gone are the days when someone will sit in jail because they are too poor to make bail.
As for bail, the problem historically has been twofold: that too many poor defendants who pose a minimal risk of danger, minimal risk of flight, sit in jail for too long pre-trial because they can't make even modest amounts of bail. And in the course of doing so, many of them lose access to families, to medication, may lose their jobs. Meanwhile, defendants who are accused of serious violent crimes who pose a significant risk of danger in flight have been eligible for bail under our Constitution, and if they have access to clean money, are able to make bail and be released, which presents a real public safety issue for witnesses, for the community at large.
The new system means when a person is arrested, police will contact a judge to decide whether the defendant will be charged on a summons or a warrant. If they are charged on a summons, they will be released. If the case moves forward on a warrant, the defendant will be held and will see a judge within 48 hours to determine conditions of release. Those conditions can range from a phone call reminding them to appear in court, to house arrest, or electronic monitoring. Chief Justice Stuart Rabner says the state is moving away from a money-based system to one that evaluates a defendant's risk and sets appropriate conditions of release.
The other end of the spectrum, defendants who pose a significant risk of danger in flight can be held without bail in line with the governor's original proposal on pretrial detention and the constitutional amendment. And the new law, as you know, provides for a Speedy Trial Act that has finite periods of time for the period from arrest until indictment and from indictment until trial, with appropriate exclusions for a number of different proceedings.
A new pretrial services division will conduct an estimated 70,000 risk assessments per year. In addition, it will be responsible for monitoring defendants released with conditions. Prosecutors can request high-risk defendants be held in jail until trial. This system has worked in other jurisdictions.
In Kentucky, for example, more defendants are being detained who present a high risk, and more defendants overall are being released pre-trial. Yet there's been no increase in the rate of failures to appear, and the arrest rate for defendants who are released pre-trial on supervision has dropped.
The new system takes effect January 1st, 2017.
And that when that happens, our state will have a better and a fairer system of criminal justice that we will be proud of.